The excavator bucket was hanging 6 feet above my great-grandmother's headstone when the HOA president told me I was trespassing. Diesel hung in the cedar shade, and orange paint ran through 4 generations of my family. Vanessa Pike stood beside a community garden sign with a site plan under her arm. "This is HOA common land now. Move your truck." I didn't raise my voice. I photographed the bucket, the stakes, and the work order taped inside the contractor's windshield. Then I asked the foreman to read the parcel number aloud. He stopped halfway through it. The number on his order did not match the fenced cemetery parcel on my tax record. He lowered the bucket and shut off the engine. That should have ended the work. Instead, Vanessa produced the subdivision's glossy amenity map and insisted her board owned everything inside the green outline. What she did not know was that the map referenced an exception recorded in an old deed, an exception no one on her board had retrieved. And when I opened that deed, I found more than a protected cemetery. I found evidence that the HOA's claim reached across another piece of land it had been using for years. But that morning, standing beneath the stopped excavator, all I had was a parcel mismatch and Vanessa's certainty. My name is Caleb Ward. I was 52 then, a 4th-generation cattle farmer and the current trustee of the Ward Family Land Trust. The cemetery sat on the eastern edge of our remaining acreage, beneath cedars my grandfather said were already tall when he was a boy. My family had maintained the ground for as long as anyone living could remember. I walked the perimeter without touching anything. The chain from the entrance gate had been cut and laid in the weeds. Gravel had been pressed into a strip of dark soil near the first row of markers. A small marble footstone was chipped along one corner, and 2 weathered boundary stones I remembered beside the southern fence were gone. I placed yellow evidence flags near the disturbed areas, keeping each one several inches away, and photographed them with a measuring tape in frame. Marcus Hale, the foreman, gave me his card and a copy of the work order. He looked embarrassed, but he did not make excuses. His crew had been told they were preparing a community garden inside land already owned by Briar Glen HOA. The order carried Vanessa's approval and a site drawing that treated my family's gate as an HOA entrance. Vanessa rolled up her map, returned to her SUV, and warned that the board's attorney would contact me. I recorded the time she left and removed the memory card from the motion camera mounted inside the fence. It showed the crew cutting the chain less than 40 minutes before I arrived. At home, I enlarged a photograph of Vanessa's map. Near the green-shaded cemetery was a notation so small I had missed it outside. Subject to exception. Deed Book 61, page 214. The county's online system did not include records that old, but my father's metal document box held a faded index card bearing the same reference. Beneath it, in his handwriting, were 4 words that changed the dispute completely: cemetery and access lane. Those 4 words explained why the green line bothered me. The dispute was not limited to the acre beneath the cedars. It also included the only lawful route from Old Mill Road to the cemetery gate. The burial ground measured 1.03 acres. 27 carved markers stood in loose rows, with several unmarked fieldstones closer to the oldest cedar. A 12-foot wide lane ran 310 feet from the county road along the edge of my pasture. My family graded it lightly each spring, trimmed the brush, and kept enough gravel on the low spots for a hearse or maintenance truck to pass after rain. That lane had never served Briar Glen. The subdivision's entrance was nearly half a mile south, marked by stone pillars and a landscaped median. A wooden fence separated its backyards from the cemetery, while my pasture bordered the north and west sides. The paper history began in 1948, when my great-grandparents sold the eastern timber acreage to a lumber company. They retained the cemetery and its approach because 5 generations of Wards were already buried there. The timber tract changed hands several times before a developer purchased it and built Briar Glen. The burial ground continued to receive its own tax notice, and the Ward family continued paying it. I knew that tax records were not final proof of a boundary. Neither was Vanessa's colored amenity map. What mattered was the chain of recorded ownership and whether the old description could be located on the ground. Until I had both, I intended to make no claim broader than the documents supported. That afternoon, I emailed Vanessa a notice of disputed ownership. I attached the cemetery tax card, photographs of the damage, the mismatched work order, and the image from the motion camera. I demanded that the HOA preserve every email, plan, invoice, and meeting record connected to the project. I also told her no board member, contractor, or resident had permission to enter through the gate. Her reply came 19 minutes later. She wrote that Briar Glen's final plat identified the area as common open space, and that my obsolete family paperwork could not override a recorded subdivision. She accused me of interfering with an approved improvement project and warned that the HOA would recover any delay costs from me. The speed of the answer told me she had not checked anything I sent. I spent the evening laying records across my kitchen table. My father's index card, the separate tax bill, and a faded sketch of the cemetery all agreed about the lane. The HOA map did not. Its green shading crossed my gate, followed the lane north, and widened around the graves. Someone had not merely misplaced a boundary. Someone had converted a long, narrow access strip into part of an amenity on paper. The next morning, an HOA newsletter appeared in my mailbox. Its front page announced that work would soon begin on Heritage Park, described as a restored, historic green space with benches, native plantings, and a walking path. There was no mention of an active family cemetery. The article thanked Vanessa for securing access without requiring a special assessment. That last phrase stayed with me. Benches and flowers did not explain why the contractor needed an excavator large enough to cut a road. Marcus called shortly before noon. He said he could not discuss the HOA's internal decisions, but he was willing to send me the complete work package his company had received. The file contained 12 pages, instead of the 2 posted at the site. On page 9, the cemetery lane was labeled Temporary Construction Access. An arrow continued beyond Heritage Park towards 6 undeveloped acres behind the northern row of Briar Glen homes. Marcus had also forwarded an email asking whether his trucks could make the turn from Old Mill Road. Vanessa had answered that the HOA controlled the full route and would handle any neighboring landowner concerns. The cemetery was not just being mislabeled as a park. Its lane was being offered to a construction project. At the bottom of the site drawing, beside the same green boundary, appeared the reference I had photographed. Deed Book 61, page 214. The drawing cited the old deed, while ignoring whatever it contained. I called the county recorder's office and learned that the book had never been digitized. If I wanted to know what the developer had actually purchased, I would have to read the original chain one page at a time. The county records office occupied the ground floor of an old brick building with narrow windows and humming fluorescent lights. Helen Brooks, the recorder, met me at a counter worn smooth along its edge. She was careful from the beginning to explain that her office stored documents. It did not decide what they meant in a contested case. That was fine with me. I had come for the paper. I wanted the sequence of transfers, not a convenient opinion from someone who had not examined the entire recorded chain. Helen brought out Deed Book 61 and rested it on a foam cradle. Page 214 was yellowed at the edges, but the typed legal description remained clear. In 1948, Elias and Ruth Ward had conveyed the Eastern Timber Tract while expressly accepting the Ward family burial ground and the access lane running from Old Mill Road. The cemetery was described by 4 bearings and distances tied to a carved stone corner. The lane was described as 12 feet wide. Nothing on the page said common land. Nothing granted access to a future subdivision. Helen then helped me trace the grantor and grantee entries without offering a legal conclusion. The lumber company had conveyed its tract to another owner in 1966. 2 later transfers repeated that the land was subject to the cemetery exception. When the Briar Glen developer purchased the surrounding acreage in 2007, its deed referred back through the same chain. There was no separate instrument transferring the retained parcel from my family. I ordered certified copies and took them to Rachel Bennett, a property attorney in the next town. Rachel did not celebrate when she read the exception. She asked how the cemetery had passed from Elias and Ruth to the current trust, whether anyone outside the family had maintained it, and whether a later agreement might affect the lane. Those were the questions I needed her to ask. Over the next 4 days, she obtained probate records, 2 family deeds, the trust instrument, and a title report. The chain showed the retained parcel passing through my grandfather, then my father, and finally into the Ward family land trust. The report found no easement benefiting Briar Glen, no deed to its developer, and no instrument dedicating the cemetery for public use. Rachel warned me that strong documents still had to match a physical location. She recommended Elena Torres, a licensed boundary surveyor with experience reconciling older deed calls and modern plats. Elena began at Old Mill Road. She measured the lane, searched the fence corners, and compared the 1948 bearings with the Briar Glen plat. The HOA map treated the cemetery as a smooth extension of its green space, but the recorded plat contained a faint break in the boundary where the old lane entered. Its notes also incorporated prior exceptions without drawing them clearly. Near the northwest cedar, Elena's metal detector sounded beneath several inches of needles and soil. We uncovered an iron pin beside a flat stone marked with a shallow cross. The distance from that point to the carved corner near the southern fence matched the old deed within inches. "That gives me 2 surviving monuments and a consistent occupation line," she said. "I still need to complete the fieldwork, but this description is locating on the ground." Her preliminary measurements placed the entire proposed garden inside the cemetery parcel. They also put all 310 feet of the lane outside the HOA boundary. The missing stones had marked 2 intermediate points, but their absence did not erase the original corners or the recorded measurements connecting them. Rachel sent Vanessa and the HOA's attorney a formal cease and desist letter. It included the certified deed, title summary, preliminary survey drawing, photographs, and a demand that all relevant records be preserved. The letter did not threaten arrest or claim that a survey alone settled title. It stated that continued entry would force us to seek temporary court protection while the ownership claim was resolved. Vanessa answered through an email to the entire subdivision. She described me as a neighboring farmer attempting to privatize a historic community space. She wrote that the board possessed a recorded plat and would defend residents' access. Within hours, strangers were commenting on the HOA's public page, accusing me of fencing off a park I had never owned. I wanted to respond with the deed, but Rachel advised me not to litigate title on social media. Instead, I saved screenshots and returned to the cemetery with Elena to finish the survey. The old gate stood closed exactly as I had left it. Beyond it, however, fresh tire tracks pressed into the shoulder of the lane. As we watched from my truck, a landscaping trailer turned off Old Mill Road. It carried wooden benches, bags of concrete, and another work order clipped to the dashboard. Vanessa had received the deed. The HOA had been formally warned, and they were coming back anyway. The landscaping trailer slowed at the gate, and Vanessa's SUV pulled in behind it. I stepped onto the grass shoulder, kept my phone recording, and told the driver that the trust had denied permission to enter. I did not stand in front of his truck or touch his equipment. Vanessa came around her vehicle carrying another printed map. "Proceed under the board's authorization," she told the crew. The temporary chain I had installed after the first intrusion was looped through the gate but no longer locked. Someone had cut away the new padlock and placed the pieces behind a fence post. The driver eased through while I photographed the damage and called Rachel. The crew unloaded 2 benches, concrete bags, and a powered auger. They set the benches between the lane and the first row of markers, then painted 4 circles where they intended to drill. I asked the foreman for his work order. He handed it over after calling his supervisor. The authorization bore Vanessa's electronic signature. Its date was 4 days after she received our deed notice, and 1 day after the cease and desist letter reached the HOA's attorney. Rachel contacted the landscaping company's manager while I called the sheriff's non-emergency number. The deputy who arrived photographed the cut lock and obtained names for an incident report. He made it clear he was not deciding the boundary. His role was to document the property damage and keep the confrontation from escalating. The landscaping company's manager ordered his workers to stop before they drilled. They reloaded the auger but left the benches where they had placed them until their insurer could advise them. Vanessa argued that the HOA would hold the company responsible for the delay. The deputy repeated that no one at the scene was going to resolve ownership and advised everyone to preserve the status quo. By late afternoon, Elena had completed enough fieldwork to certify her survey. The 1.03-acre cemetery closed within the measurements allowed by the old deed, and the 12-foot lane followed the same route my family had maintained. She marked the recovered iron pin and carved corner, referenced the missing intermediate stones, and tied the work to modern control points. Her survey did not create our title. It showed where the recorded description lay on the ground. Rachel arranged for a monument conservator named Samuel Price to inspect the site. He documented the chipped marble footstone, tire compression near 2 grave plots, scraped topsoil, the cut gate hardware, and the areas marked for drilling. His preliminary restoration estimate was $18,750. Most of that cost involved careful soil work and stabilization around the old markers, not cosmetic landscaping. The next Briar Glen board meeting drew more residents than usual. I did not attend, but 3 owners later sent me the recording. Vanessa read from a summary prepared by the board's attorney, claiming the 1948 language reserved only a right to conduct burials while leaving the underlying land with later owners. She omitted the separate tax parcel, the family chain, and the lane description. One resident asked why the board had approved construction before receiving a title opinion. Another asked why Heritage Park drawings included a road toward undeveloped land. Vanessa said the road was merely for landscaping access and ended the public comment period. The recording mattered because her explanation conflicted with the contractor's documents. Marcus contacted me that evening from his personal email. He had reviewed his company's records and found the original message he sent before the excavator arrived. In it, he told Vanessa that the parcel number on the HOA map did not match the number supplied by the county system. He asked for written confirmation that Briar Glen controlled the cemetery gate. Vanessa's response contained one sentence: the board had reviewed the issue, and he should use the access shown on the project plan. Attached to the same thread was a preliminary layout from developer representative Peter Sloan. It showed 22 proposed homes on 6 acres north of Briar Glen. Heavy trucks could reach the site from the subdivision's main entrance, but doing so required temporary removal of landscaping and part of a decorative wall. The cemetery lane offered a straighter and cheaper route from Old Mill Road. A draft cooperation agreement made the exchange even clearer. If the HOA delivered construction access by September, the developer would pay for the benches, native plantings, and walking path at Heritage Park. The board would receive a new amenity. The developer would avoid the cost and disruption of opening a route through Briar Glen. Neither side acknowledged that the land belonged to someone else. Rachel added Marcus's email, the meeting recording, both work orders, and the draft agreement to our evidence file. She also sent renewed preservation notices to the HOA, the 2 contractors, and Peter Sloan. By then, the pattern was no longer a disagreement over one colored map. The board had been warned by me, by Marcus, and by our attorney, yet it continued authorizing work. Each document narrowed the board's ability to call this a mistake. The benches remained beside the graves through the weekend. On Monday morning, Vanessa sent residents another message promising that Heritage Park would open on schedule. Rachel read it once and closed her laptop. "We have given them every reasonable opportunity to stop," she said. "Now we ask the court to make them stop." Rachel filed the complaint 2 days later. It asked the court to declare the trust's ownership, clear the HOA's competing claim, award documented trespass damages, and prohibit further entry onto the cemetery and lane. With it, she filed a motion for temporary injunctive relief, supported by my photographs, Elena's certified survey, the 1948 deed, the title report, both work orders, and Samuel's damage estimate. The HOA hired separate litigation counsel and submitted its 2007 subdivision plat, the developer's deed, and a declaration from Vanessa. Their position was that the plat identified the cemetery area as common open space, and that the developer later transferred all common areas to Briar Glen. Vanessa described the ward exception as a limited privilege to visit and bury family members, not retained ownership. Rachel's written reply was simple. A deed conveying all common areas could transfer only property the developer actually owned. The title chain contained no conveyance of the cemetery parcel or lane to that developer. The court scheduled an expedited hearing with both sides present. I sat beside Rachel while the HOA's attorney enlarged the green-shaded map on a screen. He argued that construction had already been delayed and that residents expected access to Heritage Park. Rachel placed the certified deed, trust records, tax history, and survey in sequence. She focused on the risk of augers, concrete, and heavy vehicles around marked graves. The judge declined to make a final title ruling from the temporary record. He did find that additional construction could cause damage that money alone might not fully repair. The resulting order barred the HOA, its residents, the developer, and their contractors from entering or altering the disputed parcel without written agreement or further court authorization. It also prohibited either side from moving markers, benches, fencing, or other potential evidence. By noon, Briar Glen had locked its new Heritage Park entrance from the subdivision side and posted a closure notice. The two benches remained beside the graves, but the machinery disappeared. Discovery began the following week. Rachel requested board emails, meeting packets, invoices, title communications, insurance notices, and every version of the Heritage Park plans. She subpoenaed project records from Marcus's company and Peter Sloan's development firm. The HOA initially objected that several requests were too broad, but the parties agreed on search terms and a date range under the court's scheduling order. The first production contained hundreds of routine messages about plants, bench colors, and walking path gravel. Buried among them was an email sent 6 weeks before the excavator arrived. Peter's project coordinator had attached a scan of Deed Book 61, page 214. Her message warned that the cemetery and lane appeared to be excluded from the developer's chain and recommended a title review before access was promised. Vanessa had replied the same afternoon. She told Peter and 3 board members to use the recorded subdivision plat, proceed with design, and avoid losing the September construction window. Her answer did not mention obtaining a title opinion. That email destroyed the board's claim that no one had received the old document before work began. It did not, by itself, prove every element of our case, but it established knowledge of the precise exception Vanessa later called obsolete. The meeting records revealed another problem. The board secretary's draft minutes from a closed planning session included a discussion titled Ward Cemetery Exception and Access Risk. The approved version replaced that paragraph with a vague reference to site logistics. File metadata showed the revision occurred the morning after Marcus raised the parcel mismatch. Rachel did not accuse anyone of falsifying records. Minutes are often revised before approval. What mattered was that the earlier version preserved a conversation the board's public statements denied had occurred. The HOA began to fracture under that distinction. Treasurer Lydia Chen stated in a sworn response that Vanessa had presented Heritage Park as property already confirmed by the developer. Lydia had never seen the 1948 deed before litigation. Secretary Owen Bell acknowledged that he removed the detailed paragraph at Vanessa's request because she said unresolved title language would confuse residents before the expansion agreement was announced. 2 directors then retained their own attorney and asked the HOA to suspend Vanessa's authority over the project. Residents circulated a petition demanding the full meeting records and an accounting of legal expenses. The board's insurer reserved its coverage position rather than promising payment, adding pressure without guaranteeing where the money would come from. The HOA's litigation counsel formally withdrew the statement that the deed had never been delivered. The defense changed. It now argued that everyone knew about the cemetery, but reasonable people could disagree over whether the 1948 exception retained the land itself or merely preserved family burial rights. Rachel had expected that shift. She arranged testimony from Helen about the recorded index, Elena about the monuments and survey, and a title examiner about the uninterrupted chain into the trust. Marcus agreed to authenticate the work orders and his warning email. Peter was compelled to produce the cost comparison showing why the developer preferred our lane. Vanessa's deposition was scheduled for Friday. The evidentiary hearing would follow the next week. The evening before the deposition, Rachel and I reviewed the documents in her conference room. On one wall hung the HOA's green map. On another hung the 1948 description and Elena's boundary drawing. The difference between them was only a narrow line on paper, but on the ground it contained a gate, an access lane, and 27 marked graves. Rachel placed Vanessa's emails in chronological order and tapped the first message attaching the deed. "Tomorrow," she said, "we find out why she chose the map after reading what it left out." Vanessa entered the deposition room in a navy suit with the same rolled HOA map she had carried at the cemetery. Her attorney placed it beside her chair, but Rachel began with the documents Vanessa had received, not the one she preferred to display. Rachel showed her the email from Peter's project coordinator and the attached 1948 deed. Vanessa acknowledged receiving the message. She said she had reviewed the attachment, but believed the recorded subdivision plat was newer and therefore more reliable. "Who told you a newer plat could convey land the developer never owned?" Rachel asked. Vanessa paused before answering. No attorney or title professional had given her that opinion. She had relied on statements from Peter, the green shading, and the fact that residents had occasionally walked near the cemetery fence. Rachel moved to Marcus's warning. Vanessa admitted telling him to proceed after he identified the parcel mismatch. She also admitted approving the second work order after receiving our cease and desist letter. Her explanation was that construction deadlines required the board to act unless a court ordered otherwise. Then Rachel displayed the draft and approved meeting minutes. Vanessa said she requested the wording change because unresolved legal details did not belong in a public project summary. When asked why she told residents the land was unquestionably owned by the HOA, she answered that boards sometimes had to communicate with confidence. By agreement of the parties, the court consolidated the title evidence with the request for permanent injunctive relief. The hearing lasted 2 days, giving each side time to present documents, witnesses, and competing interpretations. The HOA's attorney argued that the 2007 plat depicted the cemetery inside a larger common space area and that the developer's later deed transferred all common elements to Briar Glen. He maintained that the 1948 language preserved family burial rights without retaining fee ownership. He also pointed to years of residents walking along the outer fence and occasional HOA mowing near the lane as evidence that the area had long been treated as part of the neighborhood. Peter testified that his company assumed Briar Glen controlled the lane because the HOA presented it as available. Under questioning, he authenticated a cost comparison prepared for the expansion. Opening a route through the subdivision entrance required removing and rebuilding part of the decorative wall, relocating landscaping, and managing construction traffic near occupied homes. That option was projected to cost approximately $143,000 more than using the cemetery lane. Peter also confirmed that the developer offered to fund Heritage Park improvements if the HOA delivered access by September. He denied asking anyone to ignore a valid deed, but admitted his project coordinator had flagged the exception and recommended a title review. Marcus followed. He identified both work orders, the parcel numbers, and his warning email. He explained that he stopped the excavator because the number supplied by the HOA did not match the cemetery parcel, and because the visible headstones made the risk impossible to ignore. His testimony connected Vanessa's instructions to the equipment at the scene without asking him to offer any opinion about title. Helen described the recorder's index and authenticated the certified deeds. She traced each conveyance from the 1948 timber sale to the developer's acquisition. Every deed in that route transferred the surrounding tract, not the accepted cemetery. On cross-examination, she repeated that her office did not decide legal ownership. It preserved the recorded chain for the court to evaluate. Our title examiner then explained how the retained parcel passed through the Ward family deeds, probate records, and trust instrument. He found no gap transferring it outside the family, and no easement granting Briar Glen use of the lane. The separate tax history supported that chain, though he did not treat tax bills as title by themselves. Elena placed the documentary description on the ground. Her survey showed the recovered iron pin, carved stone corner, occupation fence, and measurements closing around 1.03 acres. She explained how the 12-foot lane aligned with the deed call from Old Mill Road. The HOA's surveying consultant did not dispute her measurements. He argued only that the legal effect of the old exception was outside a surveyor's role. Rachel agreed. That legal effect was the question before the judge. She finished with the words of the 1948 instrument, read in the context of the entire conveyance. Elias and Ruth Ward had granted the timber tract while accepting a separately described burial parcel and access lane. Later deeds repeatedly carried that exception forward. The developer's plat acknowledged prior exceptions in its notes, even though the marketing-style amenity map colored over them. No later owner could erase an excluded parcel by drawing a green line across it. The HOA's attorney urged the judge to consider the disruption a ruling would cause. Without the lane, the expansion needed a more expensive route. Heritage Park would disappear, and Briar Glen would have to explain the board's mistake to residents. Rachel did not minimize those consequences. She said they resulted from promising access before verifying ownership, not from any action by the trust. The court found that the 1948 deed retained the cemetery parcel and its access lane outside the original timber conveyance. The uninterrupted family chain placed title in the Ward Family Land Trust. Because the developer never acquired that property, neither its plat nor its deed to Briar Glen transferred it to the HOA. The order declared the trust the owner of the 1.03-acre cemetery and the 310-foot lane. It permanently prohibited Briar Glen, its residents, the developer, and their contractors from entering, altering, or using either parcel without the trust's written permission. It required the HOA to record a corrective instrument and amend any ownership map distributed to residents. The benches and construction markings had to be removed under a restoration plan approved by Samuel and me. The court left documented restoration costs, trespass damages, and recoverable legal expenses for later resolution. That kept the order grounded in evidence rather than producing an instant financial windfall. I read the ruling twice in Rachel's office. I felt relief, but not the kind that made me want to celebrate in front of Vanessa or the board. The graves had never moved. The deed had never changed. What changed was that the green line could no longer be treated as more important than either one. Within a week, the HOA requested mediation over the remaining money. Lydia and Owen called a special board meeting without Vanessa presiding. Peter withdrew the cemetery route from the expansion plan and began pricing the entrance through Briar Glen. For the first time since the excavator appeared, the next vehicle entering the lane came with my permission. It belonged to Samuel's restoration crew. Samuel's crew began by photographing every marker and matching the site to his restoration plan. Only then did they remove the benches, concrete bags, orange paint, and loose gravel the HOA had brought inside. The chipped marble footstone went to his workshop for repair. Around the older graves, his team loosened compressed soil by hand rather than driving machinery beneath the cedars. Elena returned to reset the two missing intermediate boundary stones. She placed them from the surviving monuments and recorded control points, then filed the completed survey with the corrective documents required by the order. Briar Glen replaced its green-shaded map with one that showed the 1.03-acre Ward Cemetery and the 12-foot lane as private property outside the HOA boundary. The developer abandoned the Old Mill Road route. Construction traffic for the 22 homes would enter through Briar Glen after the decorative wall was temporarily opened. It cost more, but the expense belonged to the project that created it, not to my family or the people buried beside my pasture. Mediation resolved the remaining financial claims without another trial. The HOA agreed to pay $61,400. The amount was tied to actual records: $18,750 for monument and grounds restoration, $8,650 for surveying and title work, $12,400 for removing unauthorized improvements and restoring the gate and lane, and $21,600 as a negotiated contribution toward legal expenses. Briar Glen had to determine payment through its available reserves and other lawful funding decisions. Residents received the settlement, corrected map, and unedited project timeline in a special meeting packet. Lydia presented the documents. Vanessa did not attend. She resigned the morning before a scheduled vote on removing her as president. Two directors who had supported continued construction also stepped aside. The new board adopted a requirement for an independent title review before approving any project near the association boundary. Several residents sent apologies. I accepted them without pretending the previous months had been easy. Most had believed the map and the confident messages sent by people elected to verify facts. The lesson was not that every HOA document was false. It was that no colored plan could replace the ownership records beneath it. By early autumn, the repaired footstone was back in place. Native grass covered the scraped soil, and the tire impressions had faded. I installed a steel gate at Old Mill Road with a new chain, a simple cemetery marker, and enough clearance for family vehicles and maintenance crews. It was not designed to provoke anyone. It marked the entrance the old deed had preserved. One evening, I walked to my great-grandmother's grave as sunlight filtered through the cedars. I remembered the excavator bucket hanging above her headstone and how close a convenient assumption had come to becoming permanent damage. The graves had been protected by more than paper. They had been protected by people who recorded the exception, carried it through each generation, maintained the lane, and finally insisted that the newest map answer to the oldest valid deed. When I left, I closed the restored gate behind me. The chain settled against the steel with a quiet weight. Beyond it, the cemetery remained exactly what it had always been: family ground, privately held, carefully tended, and no longer colored green on someone else's plan.